Here in this location, a great event will soon unfold. Great, not perhaps in its actuality, but rather in its consequences. On this ordinary day, will be unearthed a fantastic new legal concept. Here, while all of our passengers and workers go about unawares, legal history is about to be made.
I'm sorry, sir. I'm from the TSA, the Train Safety Administration. I need to know if you have any gels in that box.
Gels? Why, no.
Do you mind if I take a look? This search has been authorized under the Alienability of Inalienable Rights Act.
Well, okay. Go right ahead.
Well, let's see. We have several sticks of dynamite. Okay, everything looks fine. Wait a minute, what is this? Bottled water? Is this for a small child that you're traveling with?
No, ma'am.
Well, I am beside myself. People like you are the reason that Americans are hated all over the world. That's a warning. Now take your fireworks and get on the train.
Okay, my apologies.
Whoops.
You see, this is the problem with television nowadays. You can't watch an illustration of a famous court case without it turning into a bloodbath. As you can see here, Mrs. Palsgraf was clearly targeted by the scale. I mean, she came to the train station. She didn't know what she was getting herself into. Look, right there, in the frame. If you squint really hard, it kind of looks like the scale is angry. The scale is trying to get back up. If the scale commits assault, you must find fault.
That's the lamest soundbite I've ever heard.
My friends, I have so many years of experience in tort cases. I know much more about tort than that one. He wants you to think that there is a legally significant connection between the dropping of the box and the plaintiff's injury.
You know, I think what this case asks the people of New York is to determine whether we are going to find legal cause, even if it is indirect, in a case where there's a direct link between the drop box and the injury. It's time for change, New York. Can we find this connection? Yes, we can. Yes, we can!
In this case, there was no way that the guard could have known that the package was dangerous, and that pushing the passenger would thereby cause an explosion. There was nothing in the situation to suggest to the most cautious mind that the parcel wrapped in newspaper would spread wreckage throughout the station. If the guard had thrown it down knowingly and willfully, he would not have threatened the plaintiff's safety so far as appearances could warn him. Without any perception that one's actions could harm someone, there can be no duty towards that person, and therefore no negligence for which to impose liability. This court finds for the defendant.
Proximate cause? Darn tootin'. That Mrs. Palsgraf was a real maverick. This ruling by the court disregards the realities faced by Hockey Mom and Joe's six-pack. Certainly the accident wasn't foreseeable, but it was direct and traceable. And the fact of the wrong and the fact of the injury should be enough to find negligence. Notice the recent expansions in New York state law that allow children to sue for the wrongful death of a parent and spouses for loss of consortium. These expansions are based on the fact of injuries beyond the foreseen injury of the deceased and on the needs of public policy. What we do mean by the word proximate is that because of convenience, of public policy, of a rough sense of justice. The law arbitrarily declines to trace a series of events beyond a certain point. This is not logic, it is practical politics. Maverick.